Thank you for coming. We're really happy to be here. We just realized it's been 5 years since we were here, which doesn't seem at all possible, but we're happy to be here. Okay. So the IDA is the Individuals with Disabilities Education Act, and that is a federal statute that covers all public schools in the country and our territories. And essentially, it's a funding act, although it's not fully funding, and it has two concurrent tracks, if you want to look at it that way. One are the procedures, the procedural safeguards, and the other is the substantive entitlement that children who are eligible under the statute have to a free and appropriate public education, okay? So the procedures are the rules. That's the easy way to look at them. Those are the things like they have to give you written notice if they're going to have an IEP meeting. There are certain people who have to be at that IEP meeting. They have to convene that meeting at least once a year. They have to reevaluate every 3 years. Those are the rules. But in addition to the rules, the education the child's receiving is supposed to offer the child a free and appropriate public education. The most recent guidance that we have from the United States Supreme Court, because the statute's the statute, but of course, it's always subject to interpretation. What is appropriate to me may not be appropriate to you, and what a school district develops as an IEP is going to be viewed as to whether it was reasonably calculated to produce an appropriate program, not necessarily whether it actually did, although we like to know that it actually did, and that's an analysis that a court may do. Most recent decision we have is Andrew F. decision. That was the first time in many, many years that the Supreme Court actually articulated new standards for what constitutes an appropriate program. That was a very interesting case. If you're a nerd like I am, it's really fascinating to know the history of the Andrew F. case. It involved a child with autism whose parents did not believe that he was receiving an appropriate program in his public school. They made what's called a unilateral placement at a private placement and sought reimbursement under the statute for that placement. What happened in the case from a procedural perspective is that the 10th Circuit, which is where this case came out of, which is in Colorado, Andrew F. was in Colorado. The 10th Circuit had a standard. So our system of government operates as such that we have federal circuits, and so the circuits all kind of interpret the law differently, but it's a federal law. And when there is what's called a split in the circuits, meaning in the Second Circuit where we live in Connecticut, the standard for an appropriate program was one thing, which for a very long time was a meaningful education, if it was an appropriate education. The 10th Circuit standard was that an appropriate education is in compliance with the law if it offers merely more than de minimis benefits. Merely more than de minimis. De minimis is Latin for essentially more than nothing. That's what it means. And that was the standard the 10th Circuit had articulated through now Supreme Court Justice Gorsuch issued that opinion. It went up all the way to the Supreme Court, who said, yes, there's a split in the circuits. We don't want that. We have federal laws. We want people to rely on them, and that you shouldn't have very different rights in one state versus another. So they heard the case. I was actually there because our national organization had what's called an amicus brief in on it. I wasn't arguing it. I was just watching. But it was fascinating. And what the Supreme Court said is that, we actually didn't pass this law decades ago and put all this money into it and put all these requirements on educators for children to be making mere de minimis progress. That's not what we wanted. We wanted outcomes. We want goals that are ambitious. We want a meaningful education for these children. We don't want them just passing time in our public schools year after year after year. So it was it has some teeth, that case law. It's a beautifully written decision, I think. So that's kind of the standard. Now, you always look at the individual needs of the child in every single case. That IEP, Individualized Education Program, is supposed to be taking into account what is reasonable to expect for that child, what is reasonable to expect for that child for a meaningful education. So that's a quick way of summarizing. Anything you want to add, Julie?
And if I could just add, understood.org, if anybody's ever heard of that, it's understood.org, and if you Google Andrew with an E, not an A, Andrew F. Toolkit, understood.org. There's they have talking points and they have a toolkit that dumbs down, if you will, which I like when people dumb things down for me. They just give you here's what you need to know about the talking points of what came out of that case. And it's really quite helpful when you're analyzing your own child's, progress in IEP and all, so.
And when I have here that the procedures are complex, they are very complex. Even lawyers we argue with each other frequently about what they mean and what they don't mean. And they are frequently violated, not always intentionally. What you need to understand, though, is that a procedural violation in and of itself is not necessarily going to lead to a finding that the school district denied your child an appropriate program, because there has to be a nexus, a connection between that procedural violation and an actual deprivation of appropriate programming. And you can frequently make that connection. But Congress, over the years that it has reauthorized the statute since it was first passed in the 70s, has said over time, we're not just, going to do silver bullet gotchas to teachers because somebody didn't check off a box properly. You have to actually show that this resulted in a deprivation of appropriate programming for the child. Okay, Section 504, I'm not going to spend a lot of time on this today, but I just want people to understand, because people are frequently confused about how these two statutes interact and what the difference is. Section 504 of the Rehabilitation Act is a totally separate statute than the IDEA, and it doesn't just apply to education. It applies to any entity that receives federal funds. So this library is subject to the rules of Section 504, okay? Any entity that receives federal funds cannot discriminate against people on the basis of disability. That's an easy way of looking at it. But 504 has some important anti-discrimination provisions, anti-retaliation provisions for educators as well as for families and parents. It's a robust law. Where many families get confused about the difference between a 504 plan and an IEP is as follows, and I'm going to make it pretty basic even though it's a complex analysis. And there's an evolving viewpoint about Section 504 and whether we're ignoring some of the better language in 504 that might protect more students, but I'm not going to get into the weeds on that. If a student's disability requires accommodations but not specialized instruction, they would likely fall under a 504 plan. If their disabilities rise to the level where they meet criteria under the IDA and they require special education services, not just accommodations, then they would get an IEP. An easy example would be a child who has a peanut allergy. There is nothing about that allergy that requires the student to be taught differently in most cases, right? But if the student has ADD, they may have an IEP or a 504 plan. The question is, do they require specialized instruction? That's a simple analysis of a lengthy discussion, but it's just something you should be aware of. Most of us feel, in the parent side of special education advocacy, that an IEP is much more robust, requires a lot more planning, provides more protections to students with disabilities, and is far more detailed, the plan itself, than most 504 plans. I've seen 504 plans that are a paragraph, and that's it, whereas the IEP has to have a number of elements. However, as I said, there are parts of 504 that are quite compelling because, unlike the IDA, 504 actually has an analysis of whether or not the child's education is comparable to their non-disabled peers. And that is interesting in districts where you have a high standard for education. In districts where you don't have a high standard for education, it may be a double-edged sword. But
And I always just like to say that IEPs are really for when your child has lagging skills and they need skill development. It's in a 504 plan, you're not, well, you could work on skills, but there are no goals and they're not held accountable for that.
Okay. This is those anti-discrimination provisions and anti-retaliation provisions of Section 504. We see these examples, and for anyone who's interested in reading our book, we have a whole chapter on this, where many students who have IEPs also, we believe, are discriminated against under 504 in some subtle ways. Things like not making sure that you've planned for this child for field trips. That's the one that we see a lot. I have clients who are told their child can't go on the field trip unless they accompany them. Well, that would never be a standard for a child who doesn't have a disability, right? And things like not accounting for the student at graduation. I mean, we see some pretty, you've seen, I'm sure, online those awful class pictures where the child with the disability is all the way to the side and the class is all together. Those are subtle ways in which sometimes students with disabilities are discriminated against under 504, even though they have an IEP.
It could also be their parents
Of course.
on behalf of advocating for their child.
Good point.
Right. So, I've experienced situations where a district brings their attorney to the IEP meeting, but they never gave notice to the parent, right? They never gave their 5-day notice. And so that can be rather intimidating that an attorney shows up out of nowhere and you never let the parents know.
That would be both a 504 and an IDEA violation because of the notice requirements for the IEP meeting. On top of which, and I see you, I'll get to you in one second, different standards for the parents of children who have IEPs and the children that do not. We see this a lot in our schools in Connecticut. Parents of children who do not have IEPs are welcomed into the classroom to volunteer and to do reading and all sorts of things, but parents of children with IEPs are told you have to make an appointment, where someone's going to accompany you. So those kinds of different standards for families is a problem as well.
Not across the board.
No,
Yeah.
okay. Yes, I'm sorry. Yes. And who's going to be there in general? They have to give you 5 days notice of who's going to be at the meeting.
Right. You think, I always, I grapple with the word prior written notice because just the way they put the words together doesn't make any logical sense to me. But it's like you have to be notified in writing before it actually happens. So you have forewarning, like you go, okay, that's going to happen. And if you don't approve it and you get your notice, you might be able to say, no, I don't want that person at the meeting,
Or someone's not invited who I do want.
Yeah.
One of the things I love about the IDA is that the procedures, some people perceive them as being overly picky and onerous for educators, and I see that point. But what Congress said and what the cases that interpret the statute say is that these aren't just hoops we want school districts to jump through. This is not for the exercise of having a procedure. It's because if you actually comply with the procedures, more often than not, you're going to result an IEP that is substantively appropriate. So as an example, not being given notice that the speech and language pathologist is not invited to the meeting and you have a real concern about speech for your child, you would have the opportunity to say, I really want the speech and language pathologist at this meeting because I am really concerned about speech, before everyone gets together and then there's a missing person. This results in us actually having the conversation we want to be having. No. There are many areas, that's a very good question. There are many areas in the IDEA where there isn't a parity between the obligations on the school district and the obligations on the parent. And that's because it's not a statute designed to protect the rights of school districts. It's a statute designed to protect the rights of children and families. So no, you can bring whomever you want. What I will say is, practically speaking, if you're going to bring somebody who's not a member of the school district team or your team that they expect to be there, certainly a lawyer, it makes no sense to keep that from them and show up. Because if a client of mine showed up with me and they didn't know, that meeting's not going forward. They're going to cancel the meeting until they can have their lawyer there. And now we've wasted everyone's time and also destroyed some trust between you and the team.
It's a matter of courtesy, like
Absolutely.
just,
Yep.
Yeah.
But you're not required to.
Yeah.
Okay. Child find. Child find is a big topic, okay? And child find exists under both Section 504 and the IDA, actually. Child find is that part of the federal law that says that school districts must identify, evaluate, and offer programming to all students who reside in their district, even if they don't attend the public schools, who are suspected of having a disability. Child find violations occur when students are not referred for special education when they should be, or are not identified as having a particular type of disability because the district, when they evaluated the child, did not evaluate in all suspected areas of disability, okay? Child find is an affirmative obligation on the school district. That means, the words I like from one of the hearing officer decisions in Connecticut, no magic words need to be spoken by the parent. You are not the one who's required as a parent to refer your child, though you have that right. It is the school district's obligation to refer the child when the performance, behavior, et cetera, of the child merits referral. Then once referred, the evaluation must evaluate in all suspected areas of disability. Where we see some vaguer cases, for lack of a better word, are when the child has an IEP, but there's a disability that hasn't yet been identified. So I've seen many cases over the years with a child who has, let's say, an IEP for an attention deficit disorder, and the parents have suspected a learning disability for a long time. And the child's receiving an IEP, accommodations and services for that attention deficit, and the parent is saying repeatedly, I really think something else is going on here. I'm concerned about dyslexia, or I'm concerned about some kind of a learning disability. And if that child was not evaluated for a learning disability, disability. There was not an evaluation that was undertaken that would have answered the question of whether that disability is in fact present here. That can be a child find violation even if the child has an IEP. It's a much more defensible position for the school district than if the child has no IEP. Hearing officers are going to be a lot more likely to say, well, at least they were providing services and addressing this child's needs across the board, and the testing did have academic testing, but we have many cases over the years where a pretty significant disability was missed, even though the child was receiving an IEP for many, many years.
I think the other thing to be aware of, and again, I'm not saying this is across the board, but it certainly does happen, and I'm not trying to put a negative spin on anything, but we know a lot of teachers. You probably know teachers yourself, and let's face it, districts are they've got a lot of burden on their resources and money, and oftentimes people who work in school districts are told, do not refer any more children to special ed, and some teachers and staff can be under a lot of pressure not to refer kids. And I don't mean to be negative, but you have to be aware of things like that. Am I right?
You're right, and we know that because we also represent a lot of teachers' children, and they tell us that, and also many of our clients will say things like, my child's teacher said to me off the record, I can't refer, but you can refer, and you have a right to refer, and I think you should refer. We don't like to hear those things, and thankfully in Connecticut we have some very strong state legislation passed by our state organization, SEEK, Special Education Equity for Kids, which we encourage you to join because it's a great organization that protects teachers for being truthful at IEP meetings, and now under new legislation, 504 meetings, about what children with disabilities require. But
I'm not
there's,
sure it's working yet.
well,
but
it's a different conversation, and it's a small state, but there's a lot of variability from district to district.
There could be all sorts of reasons, and I don't think we can boil it down to one because we're not in every single district. It could be a strain on their resources. It could be a strain on their money. It could be a strain on
It can be a culture in that
the
district.
culture. But we can't begin to tell you how many times we take on cases where everybody knew this kid should have been referred a very long time ago. And they all know it, but the child was never referred.
Sometimes, but this is what I see with that a lot, which really troubles me. In some districts, when the child moves from elementary to middle school, all of a sudden, all of these children are moved onto a 504 plan. I've had it in certain districts a lot. It would be worthy of publication if suddenly all children in a particular district from moving from 5th to 6th grade suddenly have remediated their disability so much that they no longer require specialized instruction. So what's really motivating that is that they may know at the elementary school team when they're bridging to the next meeting that new school doesn't have the services or supports that the child's current IEP has, and they encourage them to go to a 504 plan. Some of it is scheduling, and I know this sounds incredibly jaded, and we're the first to say we're both products of public education, we believe in public education, and we are brought in when there are real problems. So we don't think this is like what happens every single day, but we have to look under the hood enough to say, what's making this happen, to find out that there are things that motivate. But there are everything from district resources to training. One of the bigger problems with Child Find, and I've said this to our legislators, state and federal, and many, many, many people, most districts train the following personnel on Child Find, okay? Special ed teachers, related service providers like speech and language pathologists, occupational therapists, physical therapists, guidance counselors, and school psychologists, most. Those are the people who are already working with the children who are already found, okay? It's the regular ed teachers, the general ed teachers that frequently have no training on IDA obligations and have very antiquated, often, views about what kind of children are students with disabilities under the statute. I heard last week at an IEP meeting in a different district than this one that my client who has severe mental illness and clearly qualifies under the category of emotional disturbance shouldn't get an IEP. Thank you. We changed it to disability. Didn't qualify because he's so smart. And I almost lost my mind because it has absolutely nothing to do with the analysis. Intelligence is only, intellectual disability is one category out of the 14 federal and state categories. So it's very frustrating. You're going to come up, people are people, right? All people have viewpoints, and sometimes they're just not trained.
And we're not trying to paint like all districts do this, but as a parent, you have to be aware that sometimes there are other factors at play. And that's why when we wrote the book that we wrote, we called it Your Special Education Rights, What Your School District Isn't Telling You. Because you don't want to learn some of these things the hard way.
Right.
Right?
Right.
So, but it doesn't mean everybody's doing it. It's just, it happens.
It's
It
important.
happens.
And the red flags I ask you to take a look at, because frequently when I'm hired, I get the child's records, and I'll start looking through them, and I'll see all of these red flags that maybe the parent even didn't realize was a red flag, like frequent nurse visits, okay? Children who are going to the nurse a lot are often avoiding the classroom, and why are they doing that? Yes. In Connecticut, as we sit here today, not as much as I wish, and this is the reason. We have a couple of very bad decisions from our federal court and some from our state hearing officers that say that the 2-year statute of limitations that we have in Connecticut that apply to all claims under the IDEA means that if the school district, if you identified a child their junior year in high school for the first time as having a disability, even though the parent has been expressing concerns for years and all the red flags are there, the hearing officers in Connecticut will say you can only go back to freshman year, even though there's glaring procedural violations throughout. That wasn't the case when I started practicing, even 10 years ago, that wasn't the case. So right now, our hearing officers are sticking to a pretty strict 2-year statute of limitations, even though I feel that child find, and it's just not my feeling, there are many cases that say child find is the exception to the statute of limitations because the statute of limitations expects that you were giving your procedural safeguards, and if you didn't have an IEP meeting and your child wasn't identified, you weren't given your notice of your obligation to take action within a period of time. I wish hearing officers were believing me when I said that, but they're not right now. So I tell my clients I wouldn't die on that hill, so to speak.
Yeah.
That said, most reasonable and responsible board attorneys, I think, share the same viewpoint of the law and don't like going into a hearing where a child has been missed for years, because even if the claims are limited to 2 years, the narrative is not good for the district, and they will try to resolve it and try to say, let's take another look at this and make sure that we have made up for what this child missed all of these years. The procedure of how you enforce your rights under the IDEA is complicated, and it's not pleasant to have to tell parents that they essentially have to act as private attorneys general, because neither our federal government nor our state government are effectively enforcing the statute. You have to do it yourself. And so you are the one who holds your child's rights until they turn 18, reach the age of majority. You are the person who has the right to take that action by filing for a due process hearing, or preferably a mediation, because it's a lot less expensive and more likely to result in a resolution and not result in a very bad relationship with the school district. But it's, enforcing your rights is a very hard thing. I say to parents almost every day, I wish there was a special ed 911 I could call when you tell me that they violated your rights, but there isn't. I have to actually follow these procedures, and they're overwhelming. And bringing in an attorney is cost prohibitive for most families, which is why we have legal aid services, and which is why the statute has a fee shifting provision for a parent if they prevail in a hearing and they want to get their fees back. It incentivizes private attorneys to say, I'll take that case because I think it's a really good case and I think I'll get paid eventually. So I hope I answered your question. Okay, go ahead.
That's why she's an attorney, I'm an advocate. I do the lighter side of the, she gets.
I get worked up. Yeah. Okay. Yeah, I was the foolish one who agreed to go to law school, right? The IEP referral process. I added here because before we started, some people had some questions of us, and I added here the link to the Connecticut Department of Education's handbook for parents, so you might want to take a picture of it, because that handbook answers a lot of the questions we were being asked. Short answer to some of these questions is that the state doesn't have a lot of very specific, nor does the federal government, very specific timelines outlined. The federal government largely defers to school districts to create their own, and states to create their own timelines for things within reason. And there's a reasonableness standard. There's words like prompt referral, prompt response. Prompt is subject to interpretation. But I usually say to families, if you're looking at you've asked the school district to evaluate your child under the IDEA, you've made an IEP referral, which anyone can do. Anyone can refer your child. You can, teachers can, your child's pediatrician can. Anyone can make that referral. If you're looking at more than a couple of weeks before they've responded to you, let alone started the process of trying to get a PPT scheduled, that's not going to be viewed as prompt. If you're looking at more than a month, unless somebody's being difficult on the parent side, that's going to probably be looked upon unfavorably by a hearing officer. Within reason. We have snow days, people get sick. I mean, everyone's going to look at the totality of the facts of the case. But you should be getting fairly quick responses to any referral, because every minute that you're not meeting as a team is time the child may not be receiving the services to which they're entitled.
But then there was another question about, well, what is generally their time to respond to you on anything? And even though there may not be set, accounted for days that's written down anywhere, if they're not, I always like to say, ask what their policy is on how quickly staff have to get back to parents when they reach out. A lot of schools have policies on that. Some don't, but some do. And then the other thing is, if it really drags out, you can always call the state and speak to your Darien representative and ask and say, look, I'm having this problem. Are you able to call up and give them a little tickle and say, there's a bunch of parents who we're hearing are not getting back to them, and can you do something about that? Because they're there to help you.
Yeah. Yes. In terms of the initial evaluation, I just can't stress this in all suspected areas of disability enough, and I'll tell you why. One of my favorite people, who is a colleague of ours in New York State, and she's also a good friend, who was a teacher before she became a special education lawyer. And one of the things she taught me 20-something years ago is that most evaluations are done with the tests that the school psychologist happens to have in her drawer in her office, not necessarily individualized for your child's disability, because those are the ones they have, they're the ones they're trained on, and they're the ones that they're going to use. And that can be very, very good. But if your child's suspected area of disability is not one that those tests are going to answer the question for, like an emotional disability, knowing a child's cognitive ability, their IQ, and knowing their achievement testing, which is telling you where they stand academically, is not necessarily going to answer that question. Does this child have an emotional disability? There are other instruments that might be needed, but sometimes the team just defers to the standard battery that they do whenever a child is referred. So you are a huge part of this process. You're integral to this process. You need to be telling your teams, this is the disability I suspect. This is what I'm concerned about. Many parents don't know how to articulate that, but you should be sharing your concerns so that you're not getting to the end of a long evaluation process and for the first time raising, I've been worried about his handwriting and fine motor skills, and there wasn't an evaluation done on that, and now we have to re-sign consent, get that evaluation. So be as transparent as possible. So there are cases that analyze when you have a rare disorder that, so as an example, most school districts don't have on their employ, like as an employee, not as a consultant, neuropsychologists. There are a couple that do, but not most, or psychiatrists. So they will sometimes refer out for an outside evaluation. You also have a right, and we're going to get to independent evaluations. Medical evaluations, not medical services, but medical evaluations are a related service under the IDEA. So as an example, there are some medical tests that can rule in or out a particular disability, and you could ask your team to refer your child for that kind of an evaluation.
But the other answer to that is, once a school district does their own evaluations, you have a right to ask for an independent educational evaluation.
And we've got a slide on that.
Oh, okay,
Yeah.
and the district has two choices: to say, yes, we will fund that, and they usually have some criteria of, they have to, that the person has to meet, or no, and if they say no, they must take you to a hearing to defend the evaluation.
Yep, we're going to get to that slide.
Yeah.
RTI, I don't want to spend a lot of time on RTI, but RTI is response to intervention, also known as SRBI in some circles, scientifically research-based intervention. There's so much alphabet soup in special education that it's really overwhelming. RTI, the history was really that Congress wanted, for reading disabilities, Congress wanted school districts to make sure that they weren't identifying children as having disabilities when in fact they weren't receiving appropriate research-based intervention in reading, as opposed to it actually being a disability. It has been way blown up into something it's not, but unfortunately we're kind of stuck with it because neither the courts nor the state or federal agencies seem to be stopping it much, into being an analysis for all students, for all kinds of disabilities. And so we have many children who are on various tiers of intervention for sometimes years without being referred to an IEP meeting. The state and federal government have issued guidance very clearly stating, no, that's not what RTI is supposed to be for. It is not supposed to delay referral for a student that you suspect of having a disability. A child doesn't have to finish tier 2 in order to get a referral. If that parent makes the referral, or if a team member does, or if they should have, it's still IDEA procedures and requirements, and it's not to be used as a elongated pre-referral strategy.
Say a word about that. Oftentimes, people who are working in school districts are all, good people. That has nothing to do with it. But they may not be informed on what is actually what the law is.
Right.
And so you have all sorts of people who will say something about, well, RTI, we do this is how we do it here. And in fact, it might be something they've just been doing for years, but it doesn't necessarily mean that that's what the actual, procedure needs to be for it.
Right. Okay, so I just want to spend a minute on that. Okay, this is a big one. We say this almost every day of our lives. Education is about more than just academics. Yes, many students who have disabilities struggle academically, but that is only one type of disability. Education is about a lot more. We expect all of our children in our public schools to be learning how to be appropriately interacting with one another socially, to learning how to cope, to becoming more resilient as learners. We expect that they're going to be good citizens. We expect all sorts of things from all of our children. And I always default to, well, do we expect it of children who do not have disabilities? Then we should expect it of children who do have disabilities, right? And so frequently the team can get mired into an analysis of grades, which are subjective, and of the student moving from grade to grade without being retained or the need to do so or the request to do so. And the Supreme Court and the cases that have been interpreted in many circuits are very clear, and it's actually in the statute, that merely passing from grade to grade does not mean you're making progress. And in the case, Supreme Court case called Rowley, which way predates the Andrew F. case, there's a footnote that says very clearly, we are not holding today that because a student is passing with good grades, they're making progress under the statute. They specifically said that that's not the case. Now, obviously, if you're going into an IEP meeting and your child is a straight A student and is doing well without any markers of other kinds of disabilities, the team's going to look at the grades. Education includes academics, but it is not just academics. And we're really passionate about that because we have many clients who are really, really good students and very capable academically, but they can only attend school 5 days a year without a ton of adult support because they are school avoidant. That's a problem. That's not accessing your education. So we spend a lot of time talking about this.
And if I could just, this is the life skills lady in me. I brought some handouts in case anybody's interested, but this is, it's just a free thing I have on my website, but I have them up here. This is the life skills cheat sheet for IEP planning. So if you want to try to talk to the folks around the team about, but this isn't about academics. There are other, because the IEP, the definition of an IEP says you have to establish the present levels of academic achievement and functional performance. And functional performance is really known as all of those skills we need to meet the demands of everyday life. There's no finite description of what it is. So this is a list of life skills that can be included in an IEP, potentially. And then this is an IEP discussion guide for life skills because many parents report to me, and unfortunately I've experienced it myself, where they'll say, well, we're not responsible for teaching life skills, or we're not responsible, or, they only need, they may not have that life skill, but they're able to access the general education curriculum without that life skill. So just to read this really quickly, lots of folks in school districts will use the standard that an IEP is a statement of academic achievement and functional performance, including how the child's disability affects the child's involvement and progress in the general education curriculum, which is usually interpreted, if it doesn't impact them at school, it's not an issue, right? But the statute goes on to say, and to meet each of the child's other educational needs that result from the child's disability and other things here. So my point is, lots of folks in school will stop after that first sentence that describes what an IEP is. So this is a guide if you've had trouble incorporating adaptive and life skills into the IEP. So they're up here if you want them.
Yes, sir. So the question for anyone who didn't hear it is sometimes it's perceived that the child is making the decision that they're not going to do something rather than that they can't do it. And that's something that's very common. So what we will frequently do is we'll ask for an evaluation where we can compare that child's behavior performance in the classroom to a typical child. It's called an ecological assessment. Sometimes we'll ask for that to demonstrate that the child is really lagging. You know, evaluations and independent evaluations we're going to get to in a minute are really a key way to demonstrate that your school district's view of things and yours are not meeting, and getting an outside person who can hopefully help the whole team say, okay, now we see this in a different light. You know, I would say there's something standing in the way. We need to find out what it is. And so, you know, when we all hear these kinds of same, you know, well, when he's interested in the topic, he does it. Well, most of us, when we're interested in the topic, we're much more likely to do it. I can tell you, I look at my email, their emails, I'm more likely to respond to more quickly because, of course, that's human nature. If it's really impacting a child to the point where they're no longer performing, you know, in their classes or attending school, because school avoidance is a big problem right now, then I would say, you know, we need to do a deeper dive here in the analysis of the data.
But I would also say another answer to that is academic achievement and functional performance. You may know how to do something, but if you're not actually doing it, that's a lack of an adaptive skill.
Right.
And it may be harmful to the student, and perhaps not, I don't know the exact example, but not being able to do, choosing not to do something
Is a problem.
In and of itself is the lack of skill.
Right. Right.
Does that make sense?
Yeah, because they're not demonstrating it. So either the child's choosing not to do what they're required to do, which is a problem, or they can't do it, which is a problem. We need to get to the bottom of it. The other thing that I hear in the same context of what Julie was talking to, sometimes more around life skills than I do in other kinds of disagreements, is we don't teach that skill to our regular education children, so why should we be required to teach that to this child? Well, first of all, we do lots of things for children who have IEPs that we don't do for general education children. But the best answer I ever heard of was an expert witness who said, if you had a child in your classroom who was having a heart attack, would you not give them CPR because you're not giving CPR to the entire classroom? That's just ludicrous, right? So you have to sometimes be, you know, ready to respond with logic. You know, the law is one thing, but logic is always a good thing. Okay, I think we went through that whole. This is the IEEs, okay? I would argue that other than a parent's right to something called stay put, which is a conversation for another day, but it's essentially a procedural protection that a parent has in a number of different factual circumstances to insist that their child continue to receive the last agreed upon placement during a disagreement with their school district about changing that placement. So stay put is, I think, the strongest procedural protection that exists under the statute because it's so strong and it operates automatically in a way that other parts of the statute don't. The IEE is the second most important, and Julie might disagree with me. She may think it's the other way around, but that's probably because I'm a lawyer and I get involved with legal disputes, and so I'm often having to exercise stay put rights. An independent evaluation is your right as a parent to say, I want a second opinion at public expense. I don't agree with the evaluation or evaluations that the school district has done, and I want a second opinion. The law around IEE is incredibly complex, and it is ever evolving. We have some not good case law in Connecticut on this topic, and I would think it's fair to say that right now in Connecticut, you have 2 years from when your school district last did an educational evaluation in any domain to ask for an independent evaluation. That's not technically in the statute, but that's how it's been interpreted, and I actually don't disagree with that analysis. When you ask for an IEE, the district's options are limited. If you've asked for the IE, they cannot ask you why you disagree with the evaluation. That cannot make that a condition upon granting it, okay? I usually suggest to parents, if you know why you disagree with it, you share that with them, right? Otherwise, it's sort of like a but many parents don't know how to articulate what feels wrong about it to them because they're not school psychologists, they're not speech and language pathologists, but it just doesn't sound like their child, or it just doesn't seem comprehensive enough. So you're not required to articulate in any kind of way why you disagree with it, but you do have to say that you disagree with it. Then, and that is in each of the areas evaluated. So you may agree with the psychological evaluation, but disagree with the occupational therapy evaluation. So that doesn't mean you have to ask for an IEE in all areas. You can simply say, I want an independent occupational therapy evaluation. The district has an obligation to then say either, yes, we'll do that, and then they have to give you their list of people who meet the criteria, although you're not limited to that list. They do have criteria, and they should give you the criteria that they have, as long as that criteria doesn't fly in the face of the right to a truly independent evaluation, which we sometimes see some questionable
Yeah.
criteria. And if they say no, if they say yes, you get to choose who does it as long as they meet criteria.
And it doesn't have to be on their list.
It doesn't. It doesn't. If they say no, though, as Julie alluded to earlier, they must file for a due process hearing without delay. In larger districts in particular, this is something that gets violated a lot, is that the people around the IEP table who've been either trained or told to say no to independent evaluations say no, and it never gets beyond that door. And we sometimes hear about it, a year or two later, the parent's like, yeah, they said no. And I said, did they file for a hearing? No, they didn't. So it's important to know. Did you want to add something, or? It's nothing, that doesn't
okay.
blow it. Many parents decide to do that. Getting a private evaluation is technically still an independent evaluation. It's just not a public expense because that person's not an employee of the district. And they're required by law to consider that information that you bring to the team. So you bring it with you, and if they use it to develop an IEP or to change the programming, you have a right to ask for reimbursement for it as well. Consider is a pretty toothless word in my view. Yes, we read it, we considered it. That doesn't, you have to kind of prove that they didn't really consider it. Well, and that's a good example of what we say, why independent evaluations are important, because, and I say this with deference to educators and administrators, and some of the best evaluations I've seen have been done by school district personnel, and I really do mean that. But Congress recognizes that there's an inherent potential conflict of interest for an educator who does an evaluation because their recommendations, which sometimes may include very costly services or supports, are being made to their employer. And so that's why parents have a right to an independent evaluation. It's one of the many reasons why, is that you're entitled to have somebody who doesn't have a vested interest in the outcome of what the recommendations are to say, and also, again, there's lots of reasons we could get into why people get defensive about independent evaluations. Most good directors will say, I'll do the independent evaluation because I actually believe that we've got it right, or I'll be happy to find out that there's something else that we could be doing. And sometimes their team is frustrated too because the child's not learning. So, yeah. No, if you got an independent evaluation, I would share it with the school.
Absolutely.
Yeah. Yeah, I know, it
But
takes a while.
The other thing I want to say is that a lot of, going back to do you have to give them a reason, a lot of school teams will say, well, we're going to deny it because my teachers did everything by the book. They did, all the assessments were done with fidelity and all that, but it's often not what they've done, it's often what they haven't done. And it's often what they haven't put in as recommendations that actually do anything to change the programming. Right? So oftentimes when you get an independent evaluation, you might have a list of 10 to 15 substantive recommendations down to, you need this type of a professional who's going to be on the team for this many hours a month, where you may not always see those kind of prescriptive recommendations in a district evaluation.
Yeah. I'd like to ask you to reimburse me for this evaluation. You can certainly ask for that.
You don't have to say yes,
but you can ask for it. No, most of them are, especially now when everyone's overbooked.
Don't you have had to have asked and first?
There's no longer that whole, like, you have to have raised it at the PPT thing has come and gone and come and gone and come and gone like 10 times. But no, you should ask for it at the IEP meeting, but you're not required by law to have done that.
Yeah.
Yes, take care. Yes, Stacey. Okay, so there's nothing in the law that says that an IEE must be raised at a PPT, but if you ask for an IE and they ask to convene the PPT, I think that's a reasonable response. A resolution session is only a function of having a due process hearing pending. That's the only way in which that comes up at all in the law. And so saying let's go to a resolution session as opposed to a mediation is dubious at best, in my opinion, okay? A mediation might be reasonable. Here's the problem. The whole reason they have to respond without delay is because sometimes it takes months to get through the other processes that are out there, especially with our State Department of Education. And that's months that the child's waiting. And if you don't come to an agreement, now we are starting back at square zero. So anything that adds to the delay around an independent evaluation, I think is questionable and not advisable if you could avoid it. Yes. There's not a set time, but you should be having it promptly, according to the handbook, promptly.
Well, and again, it's where I say, if they're, you know, keep putting it in writing, keep calling, call the state and talk to the Darien or whomever, whatever town you're from, and say, what do I do about this? Can you help me? Or find out what their policy is or their practices on how quickly they're supposed to respond to you. Because those are just other ways to get in the same door.
Yeah. You could, and they frequently will ask for that. They'll say, can
Yeah.
you give us another chance to get to the heart of that? And that's up to you if you want to
Yeah.
do that. We tend to say, depends. You know, if you trust your team and you think that they did, but there's red flags. If as an example, somebody says, which I hear all the time, usually I hear it from clients, and they don't say it when I'm there, but I've heard it enough. Well, I can do that evaluation. It's not going to change my recommendations. Well, that's a ringing endorsement for having you look into it. That's not going to instill a lot of trust that this person's really going to do a deep dive into your concerns. So it almost always depends. I know that's such a
Yeah.
lawyer's answer. Yes. So
Yeah.
you can ask for an IEP meeting at any time. You don't have to
Yeah.
wait for the annual.
Right.
You don't have to wait for the triennial to do updated testing.
Right.
Frequently we say, well, something else is going on, let's do a bunch of updated testing. Once they've done it though, that triggers your IEE rights. So it doesn't have to be a triennial to trigger your IEE rights. However, I just want to pause for something, and this is where Julie, if we were talking just the two of us, she'd be like, you don't need to go into that much detail. Section 504, evaluations under Section 504, even though there's IEE language in 504, has not yet been tested in our circuit whether the 504 3-year statute of limitations applies to an IEE request. And I don't know the answer yet, but it would be an interesting case
Yeah.
because we don't have that decision yet. So anyway,
Yeah.
sorry. I know I didn't have to go to the level. Oh, sorry.
Yeah, and then this gal right here.
I got her.
Oh, that's right. You're right here in front of me. I'll be all right.
Other questions? Urban legends. Julie and I love urban legends. And as Julie alluded to earlier, very frequently, these are not people who are setting out to mislead parents. This is just what
Yeah.
they were trained and told
Yeah.
is the law. And then they repeat it. And then they repeat it. And we frequently, when I talk to board attorneys, the ones who I talk to, and don't just only write because I don't trust them, when I talk to them, when they find out that some of these things happen, they're like, oh, geez, I really wish they hadn't said that because that's not what the law requires me. It's just that this is how they were trained by whomever their building level person was. But these are just a few of them, and there are probably dozens. This one I love. Physical therapy is only necessary for a student to access the building safely. And if there aren't stairs in the building, there's no need to work on this skill, even though there's stairs everywhere else in the world. I have looked so hard to find out where this started, and I do not know. I don't know where it started. I don't know if it only started here, but I can't get a single
yeah.
PT to articulate to me where this comes from.
Yeah.
This one is thankfully one that I think are a little past in most parts of the state.
Oh, no.
Transition services are those services that Julie's very passionate about transition, that are necessary to prepare a child for adulthood. In Connecticut, they're supposed to start at age 14 for children who have IEPs. Or earlier, but at least at age 14, the IEP that's in place by 14. And this is transition to adulthood. This is not transition to high school or transition to, it's transition to adulthood, post-secondary education, vocational, independent living. There's a whole bunch of
Yeah.
requirements in this regard. For many, many years, the only students who got transition services were the most significantly impaired students who were going to get services until the age out, which now in Connecticut is June 30th of your 22nd year. And we'll still hear teams sometimes, it's rarer, thankfully, say, oh, we don't give transition services to students who don't have an intellectual disability or a severe disability. Transition services include on the 2004 IDA post-secondary education. If you have a very bright student who's going on to college who also has a disability, they're supposed to be preparing that child for transition services for post-secondary education, which flies in the face of the very common practice in many schools to push students with disabilities out of AP and honors classes or have them forsake some important electives like foreign languages, et cetera, in order to get their services. So that's a whole other conversation.
But
Okay, go ahead.
no, I was going to say, but, you know, I've had situations where kids who are higher on the autism spectrum, right? And we've asked for them in the transition years to have their adaptive skills assessed. And I once had a reaction from a school psychologist where he said, and I'm changing sexes and everything because I'm trying not to make this personally identifiable in any way, that they were insulted that I asked that was only for people who have intellectual disabilities. And how dare I insult the intelligence of that student, whose mother has called me, and this child is now like 22 and not doing well as an adult.
Yeah.
Because I think you ended up getting that case,
Yep,
if you recall.
I think I did.
Yeah.
I know I did.
Yeah.
FERPA is the federal law that governs educational records. I like to explain that it's like the educational version of HIPAA. So every time you go to the doctor, you have to sign a HIPAA form, right? This is the educational version. I can't just pick up the phone and say, hey, it's Jen Laviano, can I have this child's records? I need your signed permission to get them. So it's a records statute. It is about records and only records. And yet, parents will ask to observe their child, and they'll say, we can't. It's a violation of the other child's FERPA rights to allow you into the classroom to observe. Well, I didn't ask to see this child's records. And every parent who pulls up and drops off kids before and after school sees other children. There's no, like, prohibition against it.
Or they'll say confidentiality.
Right, yep.
But you're not asking to find out anything about them other than you've visually seen them.
Yep, we covered the next two about annuals and triennials. Triennial testing is only to determine eligibility. No, it's not. It's also to measure progress, okay? Yes, fundamentally, it's the primary reason you're reevaluating is to determine eligibility, but it also gives you valuable information about the child's progress.
And what to do next.
And what to do next, of course.
Yeah.
The school district cannot insist that your child be medicated. They're really not supposed to even be talking about medication other than if there's medication being delivered in school. Sometimes we have a school nurse at a meeting for medical reasons. But they can't say, well, you know, your child is just bouncing off the walls and you really need to put them on some ADHD meds. It's not in keeping with the law. And you certainly can't force it. Absolutely a parent decision. And that IEP meetings don't happen over the summer. I actually have been waiting over a year for a ruling from a federal judge on this topic. There is a circuit court case out of the Fifth Circuit that says very clearly that to not convene an IEP meeting over the summer for a child who doesn't have an IEP is a child fine violation. I have that very issue in front of a federal judge, and I'm waiting for a decision on it, but
Right.
I don't know.
Can I add another one?
Yeah.
Another one would be that your child isn't going to be eligible for extended school year services unless you can prove that they've regressed.
You're psychic, Julie. It's almost like it's the next slide.
Oh, for the love of God. All right. Well, I am
This
a
is
psychic.
true.
Yeah.
This is true.
But,
yeah.
Again, if you Google Connecticut State Department Special Education extended school year criteria, presto magic, our state's criteria comes up. Bring these documents to your IEP team meeting and say, I'd like to go over the ESY criteria that our very own state put out.
ESY, or for those who might be new to this, is extended school year services in the summer typically. And so what you need to know is that there are two standards. One is the regression and recoupment standard, which is the usual and the one most families hear. But the other is if the nature and severity of the child's disability is such that they require services year round. And that one gets overlooked a lot. And also, you don't have to prove it. They'll say, well, do you have any evidence that they regressed last summer? That's not your job to figure that out. Many families, though, should keep data if they're seeing it. Some children regress over a spring break, you know what I mean? So if you have data to that effect, feel free to share it with the team. ESY must still be individualized. This is something there have been cases on. It also requires, there's a core of the statute called the least restrictive environment provision that we did not cover today, but it's very, very important, but we picked the areas that we were asked to talk on. That standard applies to summer programming. And so for students who require interaction with non-disabled peers, the summer program is supposed to provide that as well, which is frequently not something that we see enough of in the ESY programs that we have
and in
seen.
all, in deference to the school districts, it's not easy
It's
to pull
hard.
this stuff off,
Yeah.
you know?
Yep. Okay, least restrictive environment provision, and we'll spend a little time on it, but I want it to be very clear that it is one of the most important parts of the statute. In fact, the IDA was passed because children with disabilities had no legal entitlement federally to even attend our public schools. The example Julie and I give frequently is in Forrest Gump, when Sally Field sleeps with the principal because Forrest's IQ level was not high enough to meet criteria to go to school. These children were literally not going to school. And so Congress made this statute in part because they didn't want children with disabilities being segregated and warehoused and excluded from our society, and we don't either. But the least restrictive environment provision is a complicated analysis because the IEP always has to be appropriate. And for some children at various points in their education, they require more restrictive programming in order to receive an appropriate program. And that sometimes requires services that are not provided with non-disabled peers. And I, as with everything else, always look at that I in individualized education program, and we ask questions like, maybe in elementary school, this child really, the pull-out model was working well and they were in class with their peers, but now we're in middle school and they're pulled out more and more because they haven't been making the progress that we want, and they're resisting it because they want to be just like everyone else, and they're feeling badly about themselves because they think all of the other kids know that they're getting services. And maybe there's a program that doesn't have other students who do not have IEPs, but where they feel more of an authentic member of the community of that school. They go to class. They don't have a one-to-one with them in the cafeteria. They're going throughout the day with all of their peers in a much smaller environment. It's always a fact-specific analysis based on the child.
Right, and that more restrictive environment is least restrictive to that student.
Right. Least restrictive environment appropriate to meet that child's needs. The statute contemplates very restrictive programming, including hospitalizations in some circumstances.
Yeah.
And you don't have to go every step along the continuum. There are unfortunately some students who dramatically change quickly in their needs. And it's not as if the law says, okay, well, you were in a mainstream program with a pull-out for resource. Next, we have to put you in a self-contained classroom in that school. Next, we have to look at day placements. Next, we want to stay true to the LRE mandates. We absolutely do. But you always have to look at the circumstances of the child. Sometimes it becomes urgent. You have a child in crisis. Compensatory education is a remedy available under the statute and in the cases that have interpreted the statute. And it actually is an equitable remedy, meaning it's not a remedy that the statute says you are entitled to compensatory education. It's something that a hearing officer or a court would use their sense of justice to try to restore a child who missed services to the place that they would be in if they had not if they had not been deprived of the services. It's become a very hot topic post-COVID because a lot of our children we know missed a lot, and they were probably the most impacted of all of the children out there in terms of services.
And now, because staffing is such an issue.
Right, and that's exactly where we're going.
Yeah.
Staffing's an issue, transportation is an issue, getting bus drivers is an issue, getting paraprofessionals is an issue. And unfortunately, there seems to be a perception among some board attorneys, at least, that compensatory education is a judgment of misconduct on the school's part or an intention to deprive the child of services. There is no such requirement, and frequently compensatory education happens because you can't staff the service. It's just that simple. It doesn't mean that anyone's determining that you did something intentional or wrong, but the child's entitled to the services. And so what parents should be doing if they understand their rights is asking, and they're at least two legal analyses of compensatory education. The more conservative analysis is, I'll give you a hypothetical, child is supposed to get an hour a week of speech pathologist is out and they can't replace the speech pathologist, and they've missed 10 hours of speech before the new speech pathologist comes on to the case. A conservative view is that child's entitled to 10 hours of speech services. A more progressive view of mine would be, and I don't mean that politically, I mean in terms of analysis of the law, would be that you're entitled to the services you need to get back to where you would have been had you had the 10 hours. And for some children, that might be 20 hours. That's going to be an analysis that an expert's going to have to testify to really help the hearing officer understand what this child needs. Because some children, it's just, they're going to require a lot more to make up for that lost ground, okay? School districts should be offering compensatory education services to children that are obviously missing services. It's not a question of whether we agree on whether those services are appropriate. We're talking about truly missed services. But frequently we're hearing that they're not. So we tell parents, take data. You should ask for logs if you think your child, and for some parents, their child can't tell them. So if you believe your child's not receiving services, ask to have the data that that your child is and when they met with the person. And if you know that they're missing certain services, calculate it and keep track of it. And then you want to make sure you're going into your team and saying, we need to make up with some compensatory education. They've missed out on this service.
And I know you mentioned, that it might be a hearing officer who decides that, but hopefully you can decide that stuff without having
With your
going to a
team.
hearing.
Yeah.
And it could be a private conversation you have with your director, or it could be through the PPT process. But not everything should hopefully end up in a dispute.
No,
that-
and
yeah.
and you can be creative about it. Sometimes, we all say, look, we know that this child can't be, their day is already so packed and we can't pull them for any more time or add to it. Can we all agree we'll do it over the summer? And this child will get, 20 hours over the summer. I mean, we encourage people all the time to talk to their director or their supervisors and be creative, because, if you can both solve the problem together, what works for you, what works for me, that's better than having either of us in the room with you if you can avoid it. Yeah, so evaluations over the summer is somewhat different than convening a PPT over the summer or an IEP meeting over the summer. The regulations in Connecticut do allow the school district, if they made a referral at the end of the school year, the summer programs are not the summer days are not necessarily school days for purposes of calculating the timeline for the evaluation, okay? However, if the child does not have an IEP and you're saying, I suspect they need an IEP, and we need to make sure that we get the answers before the start of the next school year, I argue that that's a child fine violation to not at least convene the meeting and get started on the evaluations. There are people who can evaluate over the summer. There are ways that we can work around this. Our regulations are fairly clear on timelines, having some exceptions for the summer, but evaluations in general, there's more specific timelines than there are on things like when do they have to convene the IEP meeting if I ask them to have one.
But logically speaking, it's harder for school districts to get people to
Very
do
much
these
so.
things over the summer,
Very much so.
legitimately. It doesn't mean that you shouldn't, but it can be challenging. And I've had cases where I've said, well, if you can't get someone, let us do it on our own, and
Right.
let's consider it a mutually agreeable evaluation or something.
Or be willing to waive the attendance of certain people who
Yeah.
they just can't get there. If the director says, look, I can convene this meeting, and I even have a school psychologist who could do it over the summer. I don't have a regular ed teacher I can order here over the summer. Can we have this meeting if you agree that you'll waive the attendance of the regular ed teacher? That's just being practical. Sure, we'll do that. I still want the input of the regular teacher when they get the testing. But for now, you have to be, you don't want to be a thorn in the side of the school district on issues that you don't need to be. It's just, doesn't make sense. The handbook that I showed you, from the State Department of Education, I would say, take a look at it. I can go back to that slide so you can take a picture if you didn't. It talks very specifically in the handbook about your right to have your child evaluated when you request it. You have that right to say, I want my child evaluated. So it might be something you might want to consider a complaint. Again, we don't know all the facts here, but I'll get back to that
But
slide.
practically speaking, and again, this is just practical, right? If you give them examples of why you suspect something and the impact that you're seeing, sometimes that goes a long way versus just I'm requesting it because. There's also special provisions in the definition of an IEP for children who are in preschool, and that it doesn't have to be tied to the general education curriculum.
Right.
But again, it goes back to the definition of an IEP, and that it doesn't always have to be something that
Academic
that is impacting them
In the general
academically.
education, yeah.
But, I was just talking about this with Jen today, where they might say, well, it's not, I was just at a PPT today, and the student doesn't have any academic needs, but has lots of other needs in other areas. But they didn't want to find him eligible because they couldn't figure out how to give him any academic support from the special education teacher. And they said, because it doesn't impact his involvement and progress in the general education curriculum. Don't we have social emotional curriculum that our children do in school?
Yep.
So it's the way people are thinking about it, that it's boxed in, but it doesn't have to be if you think outside the lines. I mean, I don't think it's even a question of options, right? Because if you are in special education, right, the process must start at 14 in Connecticut, right? And so they're supposed to have, and I find so many parents don't look at the transition page, and I'm very upset about the new form where they don't even put transition on till 14, because it says, or earlier if the team decides that they want it to start earlier. But if you don't have the paperwork that even has it, how are you going to know that?
Right.
But as far as what their options are, I mean, every student who's in special education, and if they're 14, they automatically have to have some post-school outcome goal statements that drive the transition goals, right? And so the 3 areas of post-school outcome goal statements are for employment and post-secondary education or training, and if appropriate, independent living. And I think the first step is that parents need to be aware and look at the darn paperwork and follow along with all of the things that they're supposed to do, like the transition assessments and which often aren't done, or they've
much later in high school, or
Right.
they're given the same exact test that all high
Yeah.
schoolers are.
Or
We did
they're-
Naviance.
yeah.
Well, that's sort of, so all of the kids in
Yeah.
that's not an individualized transition assessment.
Yeah, or there's some very, and I'm not saying every district does this, right? But there's they can be very canned and sort of what I call throwaway goals, like, this drives me absolutely crazy, that they will take this certain assessment, but that doesn't result in a skill that you've taken an assessment. They've taken the assessment and then what, right? So you really have to read what they're putting in there. And, I was on the transition task force for too many years. And it's not the be-all and end-all, but we have the Connecticut Transition Core Skills, if you Google that. And there's some more substantive IEP transition goals that you can include in your child's transition planning. Is there another way to ask that question?
Well,
Because
and also, under the new, I just want to say, under the new legislation, every district must have a transition coordinator. It can be the director of special education under the statute, but many districts already do, but they now have to have somebody whose job it is to make sure that they're, coordinating the planning of transition.
I think the biggest thing that I would want parents to know is, and I understand why school districts say, well, we do this in this grade, and we do this in this grade, and we do this in this grade. I understand that because it's a management issue, right? You're just trying to do what you need to do. But the fact of the matter is you can do so much more. You just have to be able to introduce those ideas and say, can we do this? Well, we do that assessment in the 11th grade. Yeah, but I'm asking for it now, right? And be able to make a statement to the team like, because my son has XYZ disability, I think we need to start earlier for whatever reason, and let's get that information earlier.
And we definitely do want the student themselves to be part of that process. That's important, but that doesn't mean it's sufficient to just ask the parent what the child wants to be when they
Right.
grow up. I just had
Yeah.
a PPT where their transition evaluation
Right.
2.5 years ago says that my client wants to be an NBA basketball player.
Yeah.
And I'm like, well, I want to be tall and skinny and rich, but that hasn't happened either. So, that doesn't make it an effective transition, individualized evaluation so that we can plan.
Right.
Okay, we have a few more minutes. Yes. Yes, with, again, the lawyer, it depends that doesn't mean that when they find out, after they've done their due diligence of doing the comprehensive evaluation in all suspected areas of disability, that what it is necessarily an educational disability. So, look, you may have a child who's struggling mightily in school, I hate to use this example, but it happens because they're being abused at home. I mean, that's an awful example, but that may be what's interfering with the child's ability to hold it together in school. Does that rise to the level of being an IDEA disability? Maybe eventually, unfortunately. Some children eventually become so prevalent in their profile that they meet criteria. But, it doesn't mean that every single thing that's interfering with the child's life is the school's obligation, but certainly everything that's interfering with the child's education has to be at least evaluated if it's truly interfering. Oh, then she was right, I was
Oh.
wrong to the answer, because I thought age always matters to know where we're looking at in terms of where in a child's education they are, et cetera. But the obligation is on the school district in the state of Connecticut from age 3 until they either receive a diploma, or if they have been given an IEP through June 30th of their 22nd year, unless they are exited for another reason because they're no longer requiring services. And there are some disabilities where best practices say this is the age at which you start assessing that particular disability, and your child's younger than that and it's developmentally appropriate. However, that reason, that rationale, I would say to a parent, especially in some certain areas where we hear it frequently, should not erode your advocacy for your child that something may be wrong, because there's nothing that Julie and I hate more than hearing a parent say to us, I wish I had called you years ago. I've been so upset about this for years and years and years, and now they're about to graduate and they can't read. Or now they're, so those, we hate those. So trust your instincts. If something doesn't seem right, the answer, well, that's developmentally appropriate, maybe an accurate answer, but if it shouldn't be an answer you get year after year after year, because at what point is it no longer developmentally appropriate, and have we missed the window to provide the intervention in a way that is meaningful?
I
Other
know there was
questions?
something on here you wanted us to talk about how to craft language in documents. Is that anything anybody's interested in? Okay, so, first of all, it's terrible, but if it ain't in writing, it never happened, right? We have to, lots of times parents will call us and say, I'm getting a call a day that my child, did this or did that, but it's never put in writing, it's just over the phone. And take notes, because you've got to be documenting to show a pattern or something, right? But if you have to write to your school district, and this is just my own personal feeling, I don't like to beat people up. I don't like to be inappropriate. I like to, kill people with kindness, if you will, right? Like, dear so-and-so, let me introduce myself. My son is XYZ. I'm concerned about my child. I'm asking for this. Can we please do this? I find a lot of parents end up sending things to the district when they're really angry.
Or 2 o'clock in the morning, that's never good.
And,
Yep.
As Oprah says, don't ever put anything in writing that you will regret, right? Because you're not going
thinking
to get
clearly.
forward, right? So, but you have to remember to document, and I don't know what else you have to say, but
I would say the 2 really best resources that I know of out there to help you learn how to train yourself to become an effective advocate for your child in the practice of writing things to your district and documenting it are our book, where we do have sample letters and things of that. And Pete Wright's From Emotions to Advocacy book. It's a very good, it's Wright, W-R-I-G-H-T, Peter Wright. You can Google it. It's a very good book that kind of tells you how you can get in the practice of working effectively with your school district and putting things in writing, what things need to be in writing. Frequently, as an example, parent will write an email, sometimes the ones we wish they hadn't sent, which, we cringe when we read, but sometimes they send an email that's just a legitimate, hey, I just found out this happened today, and it's the kind of thing no school district wants to read, and they get a phone call. They don't get a response email. They get a phone call. Okay, I'm calling you back. I looked into it. What happened on the playground was this. We train parents to then say, thank you so much. Send an email. Thank you so much for the phone call. I understand that you're going to be talking to the 2 children who punched my child today, and we're going to have a follow-up meeting in 2 weeks. I hate thinking that way. I'm a 3rd-generation lawyer, so it doesn't surprise me that I think that way. I hate thinking that way because we all want to have good relationships with our children in schools. But you have to think that way, because you're going to be in this child's education throughout, and almost every year it's going to be a new team of people. Some of the people will remain the same, but you're going to have the lifetime experience of knowing your child the best.
Well, and oftentimes if something is happening at an increased degree of incidence, and you're not keeping track of it, you need to be able to say, well, this is actually impacting education. But if there's no record of it, you're just going on hearsay.
Right. It's this prompt. It's according to the handbook, they say prompt. There's nothing in the federal law that says you have to convene a meeting in a certain number of days. No, it's for any IEP meeting, I think.
Yeah.
But referrals, especially if the child is not yet identified, I think are going to be perceived as more of an urgent request than for a child who's already receiving services. But it doesn't mean that they can just sit on it and not convene it. I think, and again, it depends. If you're saying, I want to have a meeting and I want every single team member there, and I want to bring my child psychiatrist who's really hard to schedule, and I'm bringing a lawyer, and the school's bringing a lawyer, sometimes it takes a long time to get those meetings together. And a hearing officer or court may say, a month was reasonable if you have to assemble all of those people.
Right, but if you're asking for an IEE and they've denied it, then they have to take you to a hearing without delay. Again, up for interpretation,
there's now
right?
this very common response to that, which is we have 10 days to get back to you in Connecticut. That's the thing that everyone's being sort of told, and I understand where it's coming from. It's not in the federal statute, but 10 days is probably considered prompt or without delay by most reasonable hearing officers. To give you an answer on the IE request.
And they usually mean school days, not calendar days, right?
I don't think I've seen a lot of specificity, but I usually hear 10 days, so.
Okay.
Yeah.
Up for interpretation once again.
That's in everything. The draft IEP, you said, right?
Yeah.
So initial evaluations, you're supposed to get the paperwork, meaning the very first IEP your child's getting, you're supposed to get it, I think it's 3 days in advance under Connecticut regulation. I was on that committee too, and I don't remember we ended up deciding on it. And I'm rarely brought in for an initial, well, not as often as I would like. But ongoing IEPs, it's not like they're a violation of the procedures if they don't, but most best practices would say give the evaluations and the draft goals and everything like that in advance. And we tell parents, Julie has a great saying that I love, you can't change other people's behavior until you change your own behavior. If it is important to you as it is to many parents to have that in advance so you can read it and digest it, you get in the habit of saying, I want them by the Friday before our meeting. That means it's December 4th. Yeah. If I don't have it by that, I'm going to ask to reschedule, which is not fun because then you're delaying still. But at the same time, usually if you start making the process more onerous for the district as well, they'll start getting you the records in advance. And also, it just is one of those things that when I'm looking at a case, if they keep violating it, it also demonstrates a lack of respect for the family because they're supposed to be meaningful participants in the development of the IEP. You have 10 days to get back to them once you get the IEP and the prior written notice. I'm not going to have a conversation about CT SEDS because that's just a nightmare across the board, and I don't want to get into it.
But they have 5 days
to get it to you. And then, this 10-day thing is important, and I'll tell you why.
Yeah.
Our states, some are what we call consent states and others are what we call non-consent states. Massachusetts is a consent state. In Massachusetts, if you go to an IEP meeting and they propose a change in the IEP and you say, I don't agree, they must obtain your consent to implement it. Connecticut is not that. Connecticut, they send you the IEP, they say you have 10 days to take action. You have to actually file for a due process hearing to challenge the implementation of the IEP within that 10 days, or you're perceived to have waived it. So it's very important. Many parents will be like, I really don't feel comfortable. Let's see how it goes. Well, now you've missed your chance to invoke your right to stop it from being implemented. So that's an important, we could do a whole presentation on stay put. It could be a law school course, stay put, frankly.
Remember we were talking about
compensatory education, then you're going to ask for compensatory education. They're required to implement the IEP. Even during then they owe compensatory education in some format.
Keep track of what's being missed and, reach out to your director and make them aware that this is an issue and how are we going to address it.
My child's entitled to it, and it's even in the thickest days of COVID, and despite the efforts of many nationally to get a waiver of the IDEA, the IDEA was never waived. They're still required to follow it, and your child is entitled to the IEP services.
And you can get creative. I've worked with teams where they know they can't find a speech and language. This happens to be a big one, speech and language pathologist, right? So they may contract with an agency to provide the services that you take your child to after school until they can find a speech and language. Or it could be, like Jen said, we'll do it over the summer, this summer. Hopefully you'll have somebody by then and we'll do it over the summer. It's work with them. But it's a big problem. Yeah. Right. And it's a real challenge. And sadly, on a totally different note, as a system, we are driving away especially special ed teachers. They're not having fun doing this anymore.
No.
It's a problem, and it's
so that's a more global issue.
It is a global issue. It's nothing to do with our presentation tonight, but It's a problem.
It is.
Yeah, nationwide.
Yep.
Yeah. Yeah.
Okay, well, we're happy to have spent the evening with you. I know I'm starting to get the glazed eyes, I get it. And everyone has to get home to their children, and we understand it, but we hope that it was helpful. Okay, thank you.